Hello, ladies and gentlemen. We've been tasked to put together a PowerPoint to explain direct versus indirect loss with respect to bonds. My name is Eric Hurtt,
And I am Paul Overbee.
and we're two attorneys here in the Kansas City offices of Levy Craig Law Firm, and we're happy to get into it.
So beginning with just a general overview of what we're talking about, we are talking about financial institution bonds, and these are indemnity contracts. And we're talking about when coverage is extended under those types of contracts. And generally speaking, courts will look to see if losses under those contracts result directly from the covered action.
So here in our second overview, when analyzing direct loss policies, the phrase resulting directly from helps determine whether the policy will actually be covered. And there's also a very important split in the views of the court system, proximate cause versus direct means direct. The direct means direct rule requires that the loss results immediately and without intervening space, time, agency, or instrumentality from the employee's theft. It's important to also state that direct means direct is the majority view.
Since direct means direct is the majority of view, that would mean that proximate cause is the minority view. And proximate cause stems from tort causation principles, and we'll explain later that direct means direct stems from more insurance principles. It's far more common when you're looking where coverage is extended that it will arise from direct actual monetary loss.
So we have some things to look for you to look out for on a very basic level. And the Sixth Circuit tells us that when making a claim against a bond, you must establish that the loss of the money or property would actually resulted directly from one of the covered risks. And when we talk about covered risks, these are things that are in every bond that you would need to read and see what your bond actually covers. And it's very important to read that. So the insured must establish that the loss is direct, and also typically financial institution bonds will not cover indirect losses.
So what are we focusing on when we're trying to find where coverage extends? You're not going to focus on who caused the loss. Instead, you want to focus on what caused the loss. Again, this stems from contract interpretation rather than tort principles. And one example is that third-party losses are almost always considered an indirect loss where coverage is not extended.
So how should we define direct? Here we have a Collins Dictionary synonym, and the synonyms for direct are straight, without deviation, in a beeline, also immediately or promptly or instantly. You also have the Cambridge Dictionary that says directly means without anything else being involved or in between. Lastly, probably most importantly, Black's Law Dictionary defines directly as straightforward or straight in line of course. Also defining direct as free from extraneous influence. And then lastly, direct losses defined as a loss that results immediately and proximately from an event.
Now, we include those dictionary definitions not as an academic exercise, but because courts will actually turn to those dictionaries, Webster or Black's Law, when deciding how to interpret what exactly direct means. And so you're going to want to look at different forms of definitions for direct to see if maybe the different definitions may impact how you are analyzing such an issue.
To get into a little bit more legal authority, when an insured's bookkeeper embezzled funds from an insured's customer account, the court rejected the insured's argument that a $10 million settlement fell under the crime coverage provisions based on the language of legal liability of their bond. Instead, the court looked towards the direct loss stating direct means direct, and that in the absence of a third-party claims clause, the policy did not provide for indemnity for vicarious liability for tortious employees' acts. And this just goes back to reading the bond and knowing what actually is covered under your bond.
Continued legal authority here, and sort of an example in the same way. Here, funds were spent to settle contractual liabilities that arose from the underlying cause, and those payments to settle the contractual liability were deemed indirect. The reason for that being that the cause itself was a direct cause, and then the payments were sort of a secondary thing that occurred, which is, of course, indirect, and so coverage was not extended. The court here and in other places make a point to state that direct means direct is a narrower standard than simply proximate cause.
And in finding that cases have rejected arguments that loss resulting directly from should be construed to mean proximately caused by, the court points out that direct means direct is way more narrower than proximate cause, and also resulting directly establishes a causation standard that is more stringent than proximate cause.
So digging a bit into the philosophy behind these two differences here, you're going to want to note that proximate cause speaks in tort, and tort actions call on the law itself to impose their own notions of responsibility. Contrast this with direct means direct. This is not a tort-based cause of action, and this is because insurance is a voluntary agreement with known assumptions of obligations, and so the standards applied there are more stringent.
To go a little further, we have some more reminders about the fact that tort law and contract law have different goals. Tort law is based more in shifting standards, public policy, and a sense of justice, while contract law is a little bit more about what the parties actually agreed to. And with that context, we have some legal authority out of the Seventh Circuit that's talking about that a little bit more.
Now moving on to some examples that are also supported within the legal authority. This one here, a bar employee was defrauding that bar's customers. The bar owner, on his own accord, stepped in to refund those customers, then tried to claim that that refund was directly caused by the defrauding of the customers. A court would find that that refund is an indirect result, and the reason for that is because it's due to the third-party action of that bar employee.
Another real-world example is when an insured claimed that losses from fraud resulting directly from the use of a fax machine to transmit checks, the court disagreed. The issue was that the fraud was perpetuated by using unauthorized checks, not from the actual machine. And the fax caused insured to purchase the cards from its supplier, not to transfer them to its purchaser. Therefore, the use of the fax did not directly cause the loss. And this is a good example of how it may seem like something is a direct loss, but it actually is not.
Similar example here, a payroll service, after receiving funds through a computer, misappropriated the use of those funds. The person sending the payments then tried to make a claim under computer fraud language. The court, interpreting computer fraud language, found that the use of the computer was incidental, and that incidental use of the computer to facilitate the money transfer was an indirect loss. And because of that, there was no coverage.
And lastly, we have another example where an insured bank entered into an agreement with a mortgage banker to advance funds pending the close of escrow. However, once the bank got those documents and those promissory notes, they realized that those promissory notes were forged. So this ended up stopping the transaction, and subsequently the bank sought recovery under its bond for its losses, and they alleged that resulting directly from the computer fraud. However, the court disagreed, and they held that the bond would not cover the loss because it was actually not direct. More specifically, the court stated that in interpreting the terms directly as potentially applying to such a circumstance like we're talking about right now, there would be a chain of events where it would create ambiguity where none actually need to exist, because they're very literal when they say direct means direct.
So thank you very much for listening to our brief presentation on direct and indirect loss. Hopefully you now are able to differentiate between those two and can also recognize the minority view where proximate cause may apply. Our contact information is here if you have any questions. Thank you.
Thank you.